Thank you, Madam Speaker. I rise to make a contribution on the COVID-19 Disease Emergency Miscellaneous Provisions Bill No. 2 of 2020 and indicate from the outset that we have a range of amendments that we will be putting, and we will need to go into committee in order to do that. In broad terms, Madam Speaker, we are prepared to support this legislation as we were prepared to support the first COVID-19 disease emergency legislation. But as we've made clear, we won't be a rubber stamp for legislative overreach. Even in a pandemic, you need to make sure that legislation is robust, it is reasonable and it's properly scrutinised, Madam Speaker. And there is no question that the first piece of legislation that went through this place on the 26th of March was not properly scrutinised because we didn't have time to properly scrutinise it because we received the bill 1 hour before Parliament met for the day. So Dr Woodruff and I are somewhat more wary this time. In my contribution on that legislation, I made it really clear that we are here to be a constructive, cooperative and supportive part of the emergency response. We do stand elbow to elbow with the Premier and the Leader of the Opposition and every member of this place in representing our communities, making sure they understand that we are a unity ticket on their future and on the need to save lives. And that has required very significant powers to be given to government. And as I was reading through this second piece of legislation, I kept having to remind myself of the promise that the Premier made the Parliament in that last debate, when it became clear to him there was a level of legislators' distress about the situation that we'd been put in, the enormous powers that we were giving to government. And the Premier said at that time, "I will not abuse your trust." And we still hold him to that, Madam Speaker. We still hold him to that. But these powers that we're giving to government are arguably the most sweeping powers that the Tasmanian Parliament has given to any government since World War II. We're giving powers to make regulations without proper scrutiny. We're giving powers to override planning laws, to affect the way courts operate. We already have powers in the Public Health Act that can very significantly impact on the lives and the rights and the privacy of everyday Tasmanians. And that's why it's so important that when we're dealing with legislation like this, we run a very careful comb over it, Madam Speaker, and that is what we've done with this bill, which was an opportunity we didn't have with the last bill. And just on a personal note, I found that the most difficult legislative process in my nearly 12 years in Parliament, and since that day have had cause to reflect on how it might have been done differently. But anyway, that's then and this is now, Madam Speaker. When the first legislation went through this place, I was just having a look at the second reading speech delivered by the Premier. As at the 24th of March, he said in that speech there were 36 confirmed cases of COVID-19. We are now 5 weeks on from that, and there are 219 confirmed cases. 12 people have lost their lives. There's been a significant outbreak in the northwest of Tasmania, Madam Speaker, and this has impacted on the lives of thousands and thousands of people. And as we know, there are 12 family and friend groups in our community right now who are utterly heartbroken, Madam Speaker. And on behalf of Dr Woodruff and I also extend our deepest sympathy to those families and acknowledge that because we're such a small island, those deaths will be felt right across the island, Madam Speaker, as we know one of our own members in this place, is related to people who lost their lives in the northwest of Tasmania. So we are in extraordinary times, and it has provided the impetus for some sweeping powers to be given to government, Madam Speaker. And I truly believe that those powers right now are being exercised responsibly, Madam Speaker, and I truly believe that Premier Gutwein is being his best self, Madam Speaker, and doing everything within his capacity to keep Tasmanians safe. But as I said earlier, it doesn't mean we as legislators are a rubber stamp for any legislative overreach, Madam Speaker. So there are significant parts of the bill with which we have no issue at all. I'll ask some questions of the Attorney on the way through. The first amendment that we had prepared was an issue that we did raise in the briefing yesterday, and I'm pleased to hear that it was unintentional, because when I asked the question at the briefing yesterday about why there were two different definitions of an emergency cessation day, I formed the understanding that it was intentional. That one was relating to the public health emergency and the other relating to the devastating economic fallout of this pandemic on the island. So I just need the Attorney-General to confirm the amendment that she foreshadowed at the end of her second reading speech will be to Part 3 interpretation, where emergency cessation day is described as meaning the day declared under Section 17(1) to be the emergency cessation day, and that the amendment will also include removing Clause 29, I think it is, Clause 29 in Part 9 Miscellaneous, in which the emergency cessation day was going to be very arbitrary. I have to say, Madam Speaker, it was to be the Minister by notice may declare a day to be the emergency cessation day. 2, the Minister may only declare under subsection 1 a day to be the emergency cessation day if he or she is reasonably of the opinion that the risks related to the disease and the deleterious economic impact of such risks have sufficiently reduced so that it's reasonable to declare a day to be the emergency cessation day. And in the Act that we passed in haste here towards the end of March, the declaration of an emergency cessation day was contingent on the Director of Public Health advising that the public health emergency was over, and there's no reason whatsoever for there to be two definitions of emergency cessation day. So I hope that the Attorney's foreshadowed amendments correct the interpretation section of the Act, as well as bring Section 29 into line with the first COVID legislation that we passed in here. We recognise the need to not only delay the Legislative Council election, but to make sure that the term of council members is extended, and that the term that will be filled, if you like, by the next members for Huon and Rosevears will be shortened in order to bring it into line with the usual rotation of upper house elections. We too, Dr Woodruff, wrote to the Attorney-General about the need to delay the Legislative Council elections, and we are pleased that this has taken place. The obvious question that arises, given that there's a provision in the legislation for in Clause 8, when the 2020 election is to be held, 1, the Governor may, under Section 19(4) of the Constitution Act 1934, appoint by proclamation on behalf of the 2020 election a Saturday in a month before 31 December 2020. it's possible, Madam Speaker, that physical distancing requirements will still be necessary in December this year, and I'm interested in the Attorney-General's thinking on how you might conduct any election if physical distancing is still required. That is, if those circumstances that we are experiencing now, to some extent, are still in place, which would mean having people attending polling booths and having Tasmanian Electoral Commission staff being in close contact with each other in order to count votes, whether it would be possible to have Legislative Council elections in those circumstances, and whether the government is doing any further thinking on a postal ballot for Legislative Council elections. It also raises the issue of Parliament's ongoing operation, and I've written to the Premier and CC'd the Leader of the Opposition with advice that we sought from the Clerk in relation to any impediments that there may be to Parliament being able to meet remotely, and it didn't seem to me that those impediments were insurmountable, other than the question over whether or not, under the Constitution Act, we are in fact present when we're meeting remotely. And I do urge the Attorney-General to seek advice from Crown Law about that aspect of the advice that I'd forwarded to the Premier about whether or not there are any legal impediments to Parliament being able to meet remotely, debate remotely and vote remotely, because we should have the flexibility to do that. And I understand that in the first COVID Act that we passed, where a provision was made that enabled, for example, local governments or councils to meet electronically and other statutory bodies, my understanding is that that would give the Premier of the day some powers potentially to bring Parliament to meet electronically, but once you've got the executive directing when Parliament can and cannot sit and taking over determining Parliament's direction, I think you're heading into some dangerous territory, and this should be a matter for the Parliament itself to resolve, Madam Speaker. We do have some issues with the amendments that are made to the functions, to enable the functions of the Tasmanian Health Service, and particularly what would appear to some extent to be a blank cheque being given to the Tasmanian Health Service to enter into contracts and arrangements with public funds that are not subject to, for example, that are not consistent with the ministerial charter, that is not specified or is inconsistent with the service plan enforced from time to time, that would, but for this section, otherwise not be authorised under the Act. And presumably that also means those contractual powers that we are talking about giving to the Tasmanian Health Service during the emergency period will also not be subject to the Treasurer's instructions, Madam Speaker. And it's hard for us to understand why there would need to be this provision in statute, Madam Speaker, and whether or not there's any constraints, for example, on the amount of funding that the THS can enter into a contract or arrangement over, Madam Speaker. So we do have an amendment specific to that provision to deal with our concerns, and it would simply give the Public Accounts Committee some capacity to oversight large spending decisions which are being made by a government agency which is funded by the people of Tasmania. We have no issue with the changes to the Taxi and Hire Vehicles Industry Act and the Vehicle and Traffic Act of 1999. But, Madam Speaker, when you look at the first page of this legislation, which includes those two statutes I just talked about, you can see that this bill amends, and in some cases permanently, 8 pieces of legislation in Tasmania, and none of these changes have been put through a consultation process, have gone out to stakeholders. So that's why an abundance of caution, despite the circumstances we're in, is required. Because again, we are handing to government extraordinary and sweeping powers. And when I say government, I not only mean the Premier and Ministers, but also, for example, the State Controller, the Director of Public Health, and other bureaucratic entities who, under this legislation, would be empowered to make regulations, Madam Speaker. We find that somewhat problematic. In Part 6, the extension of statutory timelines, and this relates in part to a question that Ms White asked. The Relevant Licensing Act means, and that's why I think that this list of instruments is the definitive list of instruments that are affected by this clause, but I just seek the Attorney-General's assurance that this amendment does not, for example, allow the Treasurer to extend a gaming licence for a gaming control, for a gaming operator or a casino. Because that would be hugely problematic if that were the case, given that this is a matter of very significant public interest, but also very significant impact on the lives of people of Tasmania out to the year 2043, Madam Speaker. So the changes to the Emergency Management Act have prompted us to draft up a couple of amendments, and I do want to take this opportunity to acknowledge the integrity, the heart and the work ethic of Commissioner Darren Hine in his role as State Controller. As a Tasmanian who loves this island and its people, it's been very reassuring to know that Darren Hine is the State Controller. And I've just got a short anecdote here about Mr Hine. In senior public service circles, well, it used to be the case that if there was an ethical dilemma experienced at the upper echelons of the bureaucracy, the question secretaries might ask themselves is, what would Darren do? Yeah, and I can certainly see why that would be the case. So we had a briefing with Commissioner Hine a few days ago, and it was a really open conversation about the role that Tasmania Police is playing in keeping the community safe, but also enforcing directions, orders and the rules that have come about as a result of the emergency declaration. And as someone who grew up in Joh Bjelke-Petersen's Queensland, which was a police state, who has a very innate distrust in some ways of law enforcement, I am really encouraged by the culture and the practice of Tasmania Police under Commissioner Hine every day of the week, but I'm particularly heartened by his approach in this really difficult time. It doesn't, however, mean we should hand to Tasmania Police or any law enforcement agency enormous powers without putting some brakes on those powers. There is an argument for Tasmania Police to be able to hand out on-the-spot fines, if you like. But again, this is a significant change to police practice. And this is, as I recall, one of the permanent changes in the legislation, Madam Speaker. And it's a change that's come about without reference to stakeholder organisations and without public consultation. So while we support it during the emergency period, we do believe that those powers should expire at the expiry of the emergency period. And if we need to bring those powers into statute permanently, well then that's something we can do a little further down the track if it's demonstrated that this power we're giving to police is needed in the longer term. Madam Speaker. In relation to the amendments to the Public Health Act, we accept that that having the Director of Public Health need to renew the emergency declaration every 7 days places a significant and arguably unreasonable administrative burden on the Director of Public Health, and on that basis we do support bringing the declaration into a 12-week period, which is in line also with the State Controller's powers in that area, Madam Speaker. So I'm very interested to explore with the Attorney-General Clause 27 in relation to evidence. So just wanting to understand exactly what this clause would mean in real-life application in a court process. And during the briefing yesterday, when I asked if this amendment would have any implications for the Evidence Act, the answer was no. So I think it's important, if an evidentiary test is being rewritten or potentially changed in response to an emergency, I think the Parliament needs to understand why, under what circumstances that new evidentiary test would be used, and what's the genesis of this proposed amendment. Yes, I'll just move past Clause 29, hoping that that will be deleted. And now to the enormous power that this legislation would give various authorities in government to make regulations. So, Madam Speaker, when Parliament decided in the last sitting that we weren't going to return to the 18th of August, and the public record shows we all supported that. I'm not shying away from it at all. We all supported it, and as the Premier said this morning, we were all, I don't think he used the word scared, but we were all fearful because we're in the grip of a disease that medical professionals and scientists are still trying to wrap their heads around in order to understand. It is highly contagious. It is lethal, Madam Speaker, and there are a number of people in this building who would be classified as high risk. So we did make the decision not to return until the 18th of August. But since then, a number of elements of our situation have changed to a measure of an extent. We understand the outbreak on the northwest coast. There have been strong measures put in place which prevent cruise ships like the Ruby Princess from docking and disembarking. We have strong border quarantine measures in place, which I have to say, on the evidence, will be in place for the foreseeable future. But as a parliament, we've also found a way to meet effectively. We can practice physical distancing in the chamber. There are fewer staff in this building, Madam Speaker. Therefore, the risk is minimised. I don't believe it's eliminated, Madam Speaker, but it is minimised. Therefore, we have agreed as a parliament that we can meet. And if we're able to meet, Madam Speaker, then we should be able to, if the government wants to bring in extra legislation or regulations as is provided for in this clause, that's what Parliament's here for. I'm really uncomfortable, and I think every member of this place should be really uncomfortable with giving government ministers, secretaries, the State Controller, the Director of Public Health and any other senior public servant the power to make regulations when Parliament may not be sitting, Madam Speaker, when there's questions over the Subordinate Legislations Committee's capacity to, in real time, examine and advise government on measures that it's taken. We should be very, very wary of giving the executive and unelected officials the power to make regulations that impact on the lives of the people of Tasmania and, in many cases, restrict their rights and freedoms. And that's done so, to this point, to save lives, Madam Speaker. We understand that. But the Attorney-General, with the greatest of respect, did not make the case for this clause. We can't see why it would be necessary to include this in the legislation and to expand the regulatory powers of the executive and unelected public servants, Madam Speaker. As excellent human beings and administrators they may be, like Darren Hine and Mark Veitch, we shouldn't be delegating the power to make regulations to those bodies, Madam Speaker. The Director of Public Health has extraordinary powers already, and in fact many of the strong powers which are being used in this emergency period didn't come from the first COVID bill. They're already there in the Public Health Act and in the Emergency Management Act, Madam Speaker. So there's a whole suite of hefty powers that are already in place. And this strikes us as overreach, Madam Speaker. So we are concerned about it, and again, I just want to flag that we've got an amendment there that would provide for regulations made under this provision to expire at the expiry of the emergency period, that is, on the emergency cessation day, Madam Speaker. Now, I want to go to another couple of issues. The suspension of the Personal Information Protection Act in the original legislation, to us, appears to be a permanent suspension. And because everyone in government is no doubt, as the Attorney-General said before, working 20 hours a day, 7 days a week. The Office of Parliamentary Counsel has had a huge load on their plate, massive load on their plate, and so there'll be unforeseen errors or inconsistencies in the legislation that comes before us at a time like this. And our very clear understanding when when the Personal Information Protection Act provisions were suspended during the emergency in the last piece of legislation is that it would only be for the period of the emergency. But the problem is when you have a look at the legislation, the old legislation, that is not clear, Madam Speaker. So there are a number of other issues that I'm going to raise in committee. One of them is the need for the Subordinate Legislation Committee to muscle up a bit and also to have the Greens on it. But I do look forward to the Attorney-General's response to the questions that we've raised.